Y'all come in.
Professionalism every week.
Y'all come in. Ooh. Y'all come in. Y'all come in. As y'all come in, hit the like button. Hit the like button. Please utilize the like button. Come in, y'all. Y'all utilize the like button. Don't just come in to watch. If y'all come in. This is about oh my god. I just did some research, y'all. And I just realized who this person was. Y'all come in, come in, come on, real deal, come on. Y'all come on in, come on in. Those who watching, come on in. Y'all, y'all got to get them light button up for Miss Lanita now. Because I've been doing some homework. I don't give up. I don't give up for y'all. Y'all come on in and hit the like button. Man, man, man. I kind of figured this what was going on. Now y'all know. Now look. Now you know in the courtroom, this certain person been very outspoken. They've been letting Lil Woody say and do what he want to do in this courtroom, right? This ain't about Young Thug. Woody already told y'all. Lil Woody, I may say Woody, y'all, because sometimes I don't look like Woody. Y'all come on in, man. We got to talk, y'all. Come on in, come on in, come on in, and hit that like button, y'all. I just figured something out. You know, when I get quiet and I take a bit break for a minute, y'all know I'm trying to do some homework, right? And ain't nothing dumb about me at all. I'm too smart. But y'all, let me tell you this. This is the young thug. I'm so excited because I can't believe we just did a live this morning. I just figured out something and I saw something. Y'all, that's why the judge and Miss Love acting the way they acting. Oh my God. No. Watch what you say. Don't use the word KILLED in the chat, please, y'all. Please, we keep it respectful over here, okay? Kind of like take that KILLED and say unalive, okay? Y'all, let me tell you, I'm gonna let y'all listen to this. Cause this is where I kind of like stop this morning. Y'all hit that like button. Now, let me tell you, I kind of stopped right here this morning. That's why they don't want him to recuse. I found out reason why they don't want to recuse him. Why Miss Love is out trying to be like Fani Willis. See, Miss Fani Willis got some business about herself. Thank you, baby. She got some business about herself than the way Miss Love is portrayed to be. She trying to be another Fani Willis, but she can't be that woman. Okay, but look, I'm gonna let y'all see this first. Y'all listen to this, share this live. And everything I say is allegedly, but it is for educating purpose to educate my people over on my channel as usual, and for entertainment because we always miss our entertainment in with this kind of because y'all know how I like to act and stuff. So it's for criticism and this is for news reporting. And shout out to Law and Crime. But I just found out something that I had to come back in here this evening and tell my people. Okay, I'm trying to keep that phone. Uh, uh, look, y'all, look. I'm so excited. Okay, I'm gonna let y'all hear this first. Then we're gonna move on. It's gonna trip y'all out.
Also, ladies and gentlemen, if any third party would attempt to talk with you, reach out to you, email you, text you, or otherwise call you in any way to potentially
listen. Judge hasn't been saying this the whole time. He been saying some of this, partial of this, but since he got caught, pay attention. I'm about to show y'all something after this, but I want y'all to hear the end of this first. Because this is day 87. Okay? This isn't the end of my day 87. Okay.
communicate with you about this case, remember you to let myself and Sergeant Ingram know immediately. And ladies and gentlemen, and lastly is how we end most of our admonition sessions. You know, we are really appreciative of the patience and attention that you've given to this particular matter, and we'll continue to give to it. And we state that to you, and we ask that you. Every day we tell you this, but that is on behalf of all the parties.
Yeah, I noticed he ain't never talked this long, but just let him play it out.
Have given and will continue to give to this to the consideration of this matter. All right, ladies and gentlemen, unless you have any other inquiry of
for
me,
real, true.
We will talk with you on Monday.
Okay, I'm gonna check that out.
8:30, and for an anticipated 9:00 start time, and then we'll see
surely will
at that point in time. Okay. All right. Unless you have anything else,
thank you for that information, because baby, I am gonna check it out. Trust me. When y'all tell me to go check something out, I go check it out. Check Judge out. Check Judge out. Check Judge out, y'all. He don't put that earring back in his ear too. Look at that earring. See, he been having that earring out of his ear lately. Okay, I'm gonna look at that.
Okay, ladies and gentlemen, our jury has left us. Please be seated.
You've been having that little cold for a while here lately.
All right, anything else I need to take up with you all? I'm going to recess in place to allow Mr. Melnick to finish talking with Mr. Copeland. And
there she goes. There she goes, standing up.
If he or somebody else instead is going to be here on Monday. And
see, Miss Love got a job to do. Okay? She is doing her job, not the job as a prosecutor. She's doing her job that she's supposed to be doing for Fani Willis. Okay? Listen, y'all. Everything I say is allegedly now. But pay attention. She the first to stand up.
If not, we will be here on Monday at 8:30. Any other things I need to consider?
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file.
Now, this is what I need to put that ISO file. ISO with my ink pen. ISO file. Okay. I got to remember that. Okay, on day 87. Okay.
We received something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file
to be able
to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up under
headings,
with some additional pieces of a file that would have had to again have been deconstructed from the way that the file would have been given to counsel.
See, I don't find out, but I don't know this lady. She is very argumentative. I don't know why. But she's very argumentative. She loves to argue. But listen to her. She know it's gonna upset Mr. She know it's gonna upset Mr. What his name? Steele. She like that. It's something about
We
men.
are asking the court to compel defense counsel to turn over to the state.
Y'all
the
get them
file
lights up.
in the condition, in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking.
See, what she does is, I don't have nothing against this lady. I'm gonna say it once again. I'm a people person, and I listen to both sides. She will repeat herself if they don't argue back with her. She will repeat herself, and she'll keep punching at them, and the judge won't say nothing because they are a team, y'all. They are a team together. State judge, okay, not the defense.
Again, that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Now, listen to their attitude. How unprofessional you got? Why are you letting her talk to them like they kids? This is a courtroom. How you gonna say talk to them? This is not your husband or nothing like that. This is a job. This is a job, and y'all may not look at it right now. You can't be biased in this situation right here. You got to be called it the way you see it. Okay? She was talking to him. And the way she presented herself to him, that is so disrespectful for him to be a judge and she's a prosecutor. They don't talk like this, y'all. They don't talk like this to the judge. I don't care what nobody out there said. This man been taken advantage of as a judge. So that's why I wanted him to recuse himself, because I see a lot going on right here.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville,
Sir.
you allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked.
I just told y'all. He did not say nothing to her. First of all, oh gosh, I hate this even going on in this court. I just want y'all to listen to this part till I get to this part, till I tell y'all what's going on. It's not even about Young Thug right now. It's not even about Young Thug. It's about Donald Trump. It's not about Young Thug. It's about Donald Trump. And they're attacking that man right there. They're attacking him because they put him in charge. But guess who's going to bail him out? I'll show you later.
I'm appalled at you. I sit here day after day with this false allegation, just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial.
Mr. Steele, don't let them get you there, because that's what they want you at. You are giving the state what they need. They want to get rid of you. And you got a cons right there, and you need to be representing him. Okay? He's gonna have to chill. And y'all got to talk. Y'all got to talk for him. Y'all got to stand up for him. I dare him to speak. But he's oh, yeah, man. I can't believe it. Wait till I show y'all this.
I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time. Okay. And I apologize that I'm getting tempered, but I've never been treated like this.
Don't let them get you. They trying to take you down, Mr. Steele. They are taking you there, and it's not fair. But you got to be professional and hold it. Oh my gosh.
Talk about professionalism week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love it. I would.
Come on, y'all. Y'all got to rub him on the shoulder. Y'all got to rub him on the shoulder. Adam and Shaw, rub him on the shoulder. He is telling the truth, but calm him down a little bit. Calm him down because he got somebody to represent right there. That they picking on. Y'all don't see it because y'all on sides. So they ain't on none of them sides. I just want to be fair.
Die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Guys, could we strike the hominem attacks? Really? Could we strike that?
Hey, everybody.
She love that yelling and fussing like that's her husband. Like that's her husband.
Calm down. Everybody, both of you, please be seated.
Judge,
Both of you, please be seated.
you have to do something.
Mr. Steele, please do what that judge said do. Y'all gonna need some power in this courtroom. I'm telling y'all now. Y'all got to either get rid of Miss Love or recuse him. Because it's something going on right here, and it's not right. And I don't even know these people. It's not right, but I'm about to keep going. I'm about to come in here to show y'all something. Guys, still, I wish he can have better control of his attitude right now. Not the attitude, but, his anxiety right now. Because that's what Miss Love is taking him. And you got to control that. I don't have nothing against him. He too nice. He's a nice man. Oh my God.
You have threatened me with contempt. You have threatened me with jail. If you go back
and look at Miss Love. And look at him. Because it already was told to them, do what y'all got to do. We got to get rid of Mr. Steele. We got to get rid of Mr. Steele. Mr. Steele, you got to stay strong to represent it. Look at him. Look. He did threaten him to contempt him. He was mad when he did it. Hold up. Listen.
Time, we can just start in voir dire. Jury after jury. You did individual voir dire painfully. Miss Love would come in and say that you're crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the case.
Mr. Steele.
I ask you, please.
Mr. Steele.
How would you feel if you were being treated
Mr. Steele.
But Mr. Steele, you got to control yourself. You got to. And I just don't understand why your colleagues just sitting there, ain't rubbing your shoulder, ain't said nothing to you to calm you down. Just pay attention to the case. Read the title.
I gave them everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Look at Miss Love.
And Mr. Williams, to me, this is an innocent man. You talk about, Mr. Love said there's a man in the Fulton County Jail. He shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody.
They don't care about Jeffrey Williams. They don't care about Jeffrey Williams because he is connected with Trump. Everybody and their mama can see this. If y'all just coming in, read it. Please don't come in and act like you lost. Read the title and pay attention to the video. Okay? Then y'all will know. Okay? Because we don't have time to explain to one person. Okay? This is real, y'all. These boys' life is in jeopardy over here. They trying to pile all of that on this one man. They trying to put this You have had Lil Woody come in, Wally, what Lil Wally came in, Woody came in here and told them, Thug, y'all keep on, I'm telling y'all what I did, and y'all keep bringing up Thug name. Every one of them guys came and hit that stand and said nothing about Young Thug. He said they keep on throwing Young Thug name in this. But wait, y'all, I'm about to show y'all something in a minute.
Charge, and we come here for a fair trial. It's been everything but that, according to that. Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw. Now it's
communism.
And now she speaks over people. It's not.
There she goes. She loved the fuss.
I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by this way, to the state October of 2023. October 2023, that was uploaded. Give it to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it. And you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object.
There she go with that hominem attack. Well, that's what he said. What was the problem with him saying it? You said, why did you say that, Miss Love? It's not a comment. No, it's not. You want it to be about that because you know Fani Willis is in a they going at her. You shouldn't even say that. This is not what this about. That's not what this about. You want it to be about that. This lady wanted to be like men's on her. They not even thinking about her. They don't care nothing about her. They trying to protect their clients over there. It's not about Miss Love. Jesus. It's not about her. I wish you'd stay focused on the case. Jesus.
When I object.
Try to silence me. I will not be silenced.
But Mr. Steele, here's the thing. Okay, I think that Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time.
Sit down, Miss Love. Yeah, sit down. Sit your butt down.
Please be seated, sir.
Sit down, Mr. Steele.
Whatever you do is fine, but I care about Jeffrey Williams.
Let me tell y'all something. This is so disrespectful. On Mr. Steele part on this side right here, Mr. Steele I like Mr. Steele now. I'm not gonna be biased with this though. My thing is he need to sit down. He really need to sit down right now. I know he upset, but that's part of his job. He got to control that. Sit down. Judge let you say what you got to say. Listen to this.
It's obvious, sir. It's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to
we know
to the
that
best of your ability with zeal and rigor. However, I agree that there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar.
Yeah, Vernon, we know about that.
We have
We'll head over
we have a
here on
large
this
contingent
channel.
of folks that watch this trial. And I mean, and so not only for the
Pay attention, y'all. Pay attention. If you've been following us on this channel, we know this. Well, we know this. What you saying in the chat? We know this. We already covered that. We know this, but pay attention to what's about to happen, because I'm about to. I didn't know this until I went back and checked some, researched some right quick.
purposes of this, but it sends not the message I think you want it to send. All right, so
It's not
I'm gonna
making you
leave
look
to your
good,
wise
Judge.
discretion in order to do that, but I'll take up whatever I need to take up as I see fit. But I know that you all, this has been a long trial. It's very demanding, exacting, and grating on, and tiring on all of you.
On
So,
you too.
I ask you to just take a couple deep breaths and step back and see and kind of look at and just remember that you do represent of who you represent and what you're here for.
Now he really said the truth right there. But we ain't done with this. But you gotta be fair with it, Judge. You got to be fair with it.
In terms of the tape or the phone calls from Fayette County, it's the court's suggestion that, and if you want my assistance, I can always, with a subpoena, have the raw, whatever it is that you were, whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's what, I mean, and Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence, and I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury, she's saying that particular type of file has other things with it. I don't think you were given those. And that's what she's trying to get. So I'm in no way blaming anybody in this circumstance, but if you want that particular file, and I think you all should have that particular, the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all we can take it.
Now, why y'all didn't do this before? Y'all could have got that. Miss Love, the judge would have got that file for them. Why y'all fussing? Because it's not about Young Thug. It's not. I wish y'all to stop, man. Doing that, boy. Is
Pick that up, and it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other.
Yeah.
Some things you just can't take back. And remember,
That's true.
Y'all are going to see each other over and over and over again, and it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right. So I'm just going to recess, and we'll see where Mr. Melnick is at that point in time, and then I can talk about Monday for certain. Okay. All right. Okay. I'm just going to recess in place. All right.
Well, listen to this, y'all. Listen to what? After the reset. Look, y'all, listen. The love ain't finished with the... Listen to this. We back. Wait, y'all. I got something else to show y'all. Hold up. We just come back
That's
from
a good
the break.
suggestion.
Can we use your house to trial our
Hold up.
new energy-saving windows? We're looking for homeowners in valid states to test our new innovative window.
All right.
We'll prepare,
Yes, Lieutenant Walker. So that will not be an issue? Okay. Okay. But we'll go ahead and have him, if you could also have him housed separately too? Okay. Okay. Thank you. Thank you, madam. All right. Anything else, councils? All right. Take a couple deep breaths this weekend. Take a knee, and come back on Monday, and let's get after it again. Okay. All right. We'll see you on Monday morning at 8:30. Okay.
Can you get us the list of names and then any exhibits for Monday?
I think the only I don't know who is being called. We can find out. Miss Love and Miss Hilton and Mr. Atkins. Who is going to be called? Let's assume that Mr. Copeland invokes again.
Yeah.
Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So
Okay.
we have to do that. We have to deal with that and where we are right now.
Fine.
And that's just where we are.
Okay. Well, be thinking about what scenarios you'd like to have the court look at.
Yes, Your Honor.
Depending upon what Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
Fine.
And Your Honor, go ahead.
Madam.
Mr. Sharp, he can have the floor.
You gone. He told you to go.
I'm just concerned.
Y'all so childish.
We just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends. The attorneys would like to have a discussion with our clients.
Lieutenant Walker.
And Your Honor, the state has a matter we need to take up ex parte with the
Okay. All right.
Now she want to be around them. Now she want to be that lady right there is something else, boy. Want to do the same thing they want to do. That never know he be is in this courtroom right here, honey. Woo!
Walker has been asked by defense counsels
That never know
as
he's
a corporeal body for them to be able to talk with their clients once you clear the courtroom.
Yes.
Can you make that happen?
Yes.
Okay, all right. So once everybody is cleared the courtroom, you just secure it, let them be in here along with their clients. Okay? Oh yeah, once we go down.
Okay.
Yeah.
I'll make that happen.
Okay, all right. Okay,
One last thing, Your Honor. I just thought of this. Your Honor probably already thought of this. The no contact order with Mr. Copeland should probably also include not just these gentlemen, but other gentlemen that are on this indictment that are not sitting for trial. I think that would probably be. Okay.
okay. All right. Okay, we'll see you Monday, okay? 8:30. We're in recess.
look, y'all. Now, look. So y'all take where that is. Okay, so now I want y'all to listen to this. And then I'm about to show y'all somebody in the courtroom. And then we're going to look at some papers. Whoa, look, y'all.
8H then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's
Y'all heard who there? Oh, look at you. Look at you. That's what I want y'all to see. Y'all look at the judge. Y'all know who representing Mr. Steele, don't you? Y'all know who representing Mr. Steele, don't you? Whoa, look at the judge. Ashley Merchant is representing him. That's why the judge looking like that. Do y'all know who Ashley Merchant is? Ashley Merchant is Donald Trump. Used to work. Wait, hold on, y'all. Hold on for a minute. Hold on. God, let me see. What I do? God, I hit the wrong button. Hold on, y'all. God, I just hit y'all. Hit my chat. Hold on, y'all. Ashley Merchant is trying to sue Fani Willis. That's okay. I ain't gonna bust it. I ain't gonna bust it. I'm about to let y'all see something. Hold on, y'all. Let me fix this for y'all. Hold on. Okay. Here we go. Look at Judge. Look at Judge. Look at Judge. That's who representing Mr. Steele, Ashley. Cause he was trying to lock Mr. Steele up for 20 days. Okay. Dun dun dun.
The president.
Okay, all right. We'll let Ms. Merchant in. That's fine. Ashley Merchant. Yeah, Ashley Merchant.
Ashley Merchant, yeah. Ashley Merchant is present.
All right. Ms. Merchant, good to see you as usual. I have told.
Look, see, good to see you as you. Y'all. She tried to sue Fani Willis. Ashley is representing Brian Steele. Oh my God. Y'all. Ain't this court crazy? She is representing Mr. Steele. Mr. Steele is representing Young Thug. God, this is crazy.
Your client, represent Mr. Steele, is that correct? Yes. For the purposes of the contempt, I've entered the order, entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosed.
Listen, y'all. Listen. Hey, Glanville didn't know that's who Mr. Steele attorney was. Oh, getting real in this Rico.
That, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no superseded bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of his contempt.
Judge getting kind of scared now. He get this mother sucker getting real. Because that means that, hey, this is Mr. Steele attorney is Fani Willis' rival. And this is the Rico case. How that happened? Lee, what is going on in this courtroom?
Tim, only thing I want is because of the way this information was disclosed, it is troubling to the court and is very, since it was a ex parte communication.
Well, Judge, you did wrong. What you did, you took the defense in your office. It had a conversation. But y'all left the defense out. Y'all just stay everybody in the room. And you feel like he get nervous now.
We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client the last time if he would tell me who it is that disclosed that information.
Judge, come up to the microphone. Sorry.
Please. Microphone, it'll pick up, madam.
Thank you so much. Just for record,
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great, thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order the court. If counsel, as you know, if the court orders you to do something, don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much.
Hey. Look at me, love. Look at me, love. You want to be professional right now, don't you? Cause you see your colleague rival in the court representing Mr. Steele. I know y'all over there emailing folks that your girl in here representing Mr. Steele. Let's see what Ashley Merchant has to say.
Detail of this particular alleged conversation for the court concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had tell me who it is that is it. So a little different, Ms. Merchant. I won't disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399.
She ready. Yeah, y'all, that's Ashley right there. Miss
And it says that is one of the cases. Also, two other cases. Henry Adams, 215 Georgia App 372.
Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
Look at me,
215
love.
215.
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those.
I see you ain't bobbing your head over here with Miss Ashley Merchant. Mr. Merchant came with the darn receipt, boy.
You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other.
What you said, Truth? Cut to the. I just realized that was Miss Merchant. Boy, I'm telling you, stuff opened up my eyes. And
I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've got space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that.
scared now, ain't you, Judge? Ain't you scared now? You don't want to recruit. You know if you fool with Mr. Steele right now, you're gonna have to come out from down there. Y'all gonna have to go to court. And then another judge got to get in your spot. So we still looking to recuse. Okay? So since you don't want to recuse now, you go, hey, let's see what he gonna do, y'all. Here we go. Camper, stop.
Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H. and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys, they're all members of the bar. I can give you all their
He
names.
still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom, so we would ask that they be allowed
I
to.
don't want them in my jury box, okay?
What?
I understand.
What? Look at y'all trying to get an attitude. I don't want it in my jury box. Judge. Oh, the real Granville coming out of you. Okay. Okay. Miss Miss Merchant is ready for you, bruh. Ooh, where is his dog at? Miss, look. You ain't moving your head now, ain't you, Miss Love? You got a real person in here now.
May, one additional attorney, and then Alex Sousa. And we're here on behalf of Gackel, is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney, co-counsel?
He's scared.
Great. Alex Sousa. Alex Sousa. Thank you, Judge.
What up?
Henry Adams, it has two issues. One is the motion for disqualification. Okay. And that's
Look at me, Love. Scared now.
and I think the judge went ahead and did some other things that caused that issue presented. So
This is the
I'll
truth.
take a look at the other case. That was Henry Adams. That was 215 Georgia 372.
Yes.
The other case just a second.
And there's several others when you're ready.
Look, they can't sit down. Prosecution can't sit down. They don't even supposed to be walking around. Mr. Weston ain't playing with him, boy. Mr. Steele ain't playing with him. Yeah, they trying to reach out to Fani Willis. I think Miss Fani Willis would have did a better job than this team right here. Yeah. Y'all, that's Miss Ashley Merchant. That is Miss she and Miss Fani Willis are rivals right now. Okay. I told y'all I'm about to bring it to y'all today. I got something else for y'all to see after this. This is deep, like you said. Okay, Rodolfo, sit down. Camper, sit down.
Yes. It may be one I have too.
Look at him. Move, Camper. Yeah, I'm talking to my dog. I'm sorry. Look. Look, he's scared. He's scared. Go call Fani Willis. And I'm using you call him move, Camper. Look, you ain't doing that bobblehead now, this is Miss Sit down, Camper. Not playing with you. Sit down now. He scattered firecrackers, y'all. They firing them fireworks. That's it.
Casey's conduct didn't rise to a level and that's just didn't warrant summary contempt by the court. That's the difference with Casey than in this particular case. So I distinguish your two cases that you've given me thus far.
So those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also
You said 279 Georgia what, I'm sorry?
Georgia 13.
Georgia 13? Okay.
Mm-hmm. It's a 2005 case, and it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
Me little acting like no.
See, but you're all covering under, let me see.
I'm sorry, Judge.
Hold on. Just a second. Pardon me.
Don't get nervous. Look it up, Judge. Look it up. You brought it here. You contempt him, so he handle his business. Miss Love ain't over there trying to be the boss. Since another woman in him with power. Mr. Steele don't mess around. Mr. Steele got an army full of army full of attorneys out there, boy. That man some money. Love me, love ain't acting today. I can't believe that's now. that go Miss Fani Willis rival right there, y'all.
Contempt is directed. Trial court has the power after conforting the contempt order to opportunity to speak in his own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So.
And Judge, there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. And as to how that information was disclosed, that's a real problem. That's why it's of such.
What you doing with that, boy? Okay,
such an issue for the court.
Let's go to
time.
Let's have.
Mr. Steele has a right to make a motion like this. If there were
He does. I'm not saying anything, but
Don't get mad, Judge.
But he's kind of put himself in a particular position.
No,
Judge, I don't agree.
No.
I believe that.
I'm gonna disagree with you.
no,
I
he
believe
didn't put
that the court
himself
has
in
put him that
this.
position.
No.
He cannot be held in the law states, McClarity, which I.
It is true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder, obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking this to release or
You go to court for that.
tell any conversations, but
Y'all got to go to
I
court
just
for
want
that.
him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in
So
contempt.
you can come into court, Mr. Merton, and not answer a question of the court and not be held In contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there was
Look at Miss Love. She ain't gonna try
You are
to.
a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte
That's
if you
right.
weren't part of them by nature.
That's right.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the
summarily hold him in
information.
contempt.
But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that.
But you're not listening to her though.
Judge, let's just back up for a second.
That's right.
He makes a motion because he has reason to believe that there were ex parte
That's right.
communications made. The court has. There are ex parte communications made to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this. You are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge.
That's right.
And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify.
That's right.
You are necessarily a witness.
That's right.
You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I told you I had something for y'all. Wait till this. Wait till this, True.
I'll let an appellate court decide that.
Look.
So, anything else?
He getting an attitude.
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case.
Can't tell that man that you can't threaten him like that with a contempt because they not telling you what you want to tell.
He's filed a motion to set aside the contempt. He's filed a motion for a superseded bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that.
He's not gonna do that.
He can do it right now. He can do it any.
We're not doing it like that.
If not,
No.
this circumstance on Friday.
And Judge, we would ask that you grant a bond. At this point, grant him a bond on that issue.
You don't get a superseded bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
Just the case law on that is Hold
on.
You don't know the law. You don't know all of the law, Judge. You've been playing. You ain't been in no RICO. She got her own law firm. Oh Lord, I hope this thing don't come out.
The supersedes bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13.
You sure want that man locked up like they trying to recruit you.
So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's right.
That's correct.
The judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeal 66, lays out the distinction, as does the Ramirez case.
There's a case that, in fact, I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Which is, I think I'm addressing a slightly different point of
It
law.
is. Hold on.
No, don't be getting mad, Judge. Come on now. Where's your dog? Calm down now.
Give you two cases. One is
Y'all need a judge. You and him
it's,
need.
UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the difference between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's SYVERTSON, and that is 368 Georgia Appeals.
That man right there know the law. You got you a good one, young thug. You got you a good one.
Decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant a supersedious.
and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he when he tells me what
He ain't got y'all go to court.
I didn't ask what, but he tells me that, then I can certainly
No, Judge.
himself of the contempt.
It don't work
That's
like
civil, Judge.
That's civil contempt.
That's civil.
Judge, and
That's civil.
Respectfully, I would point you to N. Ray Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer
He
the
sure
question,
do,
to
true.
disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is a position to be in. And Mr. Steele is a zealous advocate for his client. And he is simply trying to protect that duty of loyalty and duty of confidentiality because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license.
That's right. Let's go to
And
court.
so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you
Yeah, he
to
needs
do
to step
something,
down.
order of the court, and you don't follow.
He don't want to.
I didn't ask him to do anything illegal, immoral, unethical.
Yes,
I
you
just asked him to
did.
tell me. I know what the
which is, I believe, got it backwards.
what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person.
Nobody.
Okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well,
That's
you
right.
get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about this a second. Okay, I'm gonna take 5 minutes out. I'm gonna think about it.
He gonna think about it.
Okay, all right.
Yeah.
We'll be in recess about 5 minutes.
Okay, we come back, y'all. I told y'all, wait, I got something else for y'all. Ooh, wait, let me pull it back. Okay, he went to think about it. Let me see. He thought about it. Yeah, I got something to show y'all. Hold on. Let me see. They done came back right here. Okay. Judge don't want to leave that. Don't want to not make that name. Miss Love can't help you with this.
Sean Brown's everybody present? Needs to be present? All right, thank you for your patience, counsels. The court's had an opportunity to reflect, and
Yes. True.
Mr. Steele, if I could ask you to take the podium, please, as well. Now stand next to your attorneys.
Look at me, love. Whispering. They need to move that TV off in front of her, too. Maybe she'll do right.
Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar.
What? Spell your last name for us.
SUSOR, Sierra, Uniform, Sierra, Oscar.
You're a good man. Good man. Okay, all right. Okay. All right. Thank you, sir. Okay, Mr. Susar as well. All right, counsels, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. You'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask you a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make
That ain't gonna happen,
work,
y'all.
okay?
That ain't gonna
If that
happen.
should occur, okay? All right. Okay. All right. All right. Counsels, I'm done with this, unless you have anything else. Thank you, Ms. Thank you, Ms. Merchant.
Okay, now let me show y'all this. Hold on.
Okay, all right.
Hold on, y'all.
Did we get a copy of that?
Yes, in fact, the clerk is going to file a it's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there, directly download from there.
And Judge, Ms. Merchant and I will file entries of appearance on behalf of Mr.
Look at them
Church.
back there
That'd be
laughing.
great. Thank you so much. Okay, all right.
Judge, I think you don't get yourself in some trouble.
All right, State, is there anything else we need to, any defendants, is there anything else we need to take up before tomorrow morning? Mr. Copeland is going to rejoin us tomorrow morning, so we'll continue with his testimony.
She don't want to have nothing to say because she got a real attorney in there with her. But let me let y'all see this. Ooh, Lord, honey, that was something else. But look, y'all, let me show y'all this. That was Miss. Now let's look at this. It's not gonna talk, but it's gonna. It said that rapper Thug was booked into Atlanta for the cat. I'm just gonna let it play. It's not gonna talk. Committed no crime whatsoever and will fight to my last drop of blood. Okay? Now, I want to share something with y'all. Okay. Oops. Come on. Put that back. Come on. God, dog it. Hold on, y'all. Let me find. I want to put that back. Hold on. I gotta put that back. Okay, here we go. Okay, this right here. I hate I lost it. I hope I'm where I was. Okay, then what I want to tell y'all that the information. Okay, the lady that was Miss Ashley. Okay, the Fulton County District Attorney Fani Willis' rival, Ashley Merchant. I didn't know that was Ashley Merchant. That was Miss Fani Willis' rival. Scored a win in Georgia Supreme Court after the justice granted an emergency motion for a bond in okay. In other words, Mr. still got a bond. Judge said he couldn't get a bond, but look, they went over. He got a bond. So emergency emotion for bond. Hold on, y'all. And Young Thug YSL Rico trial. I knew he could have got a bond. He can't just be sitting there like that. Okay, they let y'all know about the judge. Okay, he ain't up. Must still end up getting a bond. The court issued an order Wednesday afternoon staying the 20 days jail sentence that Euro Glanville imposed on Brian Steele. The attorney representing Young Thug penning the resolution of Steele appeal, Glanville ruling holding him in criminal attempt. Okay? Talking about that man couldn't get a bond, he ended up getting one. Steele himself is being represented by Merchant, okay? The criminal defense's attorney who led the effort to disqualify Willis from the election interference case against former President Donald Trump and his allies. Okay, Merchant rose to national prominence earlier this year after revealing that Willis was in a relationship with Special Prosecutor Nathan Wade. That's who that lady was, y'all, who represent him. The revelation led to several days inventory hearing that embarrassed the district attorney. Okay. The judge in the Trump case ultimately ruled that Willis could remain on the prosecution. I hope she can. But in his decision was appealed by Merchant and others to the Georgia Court of Appeals, which has agreed to hold a hearing in the matter in October, and which has indefinitely halt the case against Trump until then. Trump denies RICO charges around alleged election interference in Georgia. Okay. Oh, Lord. Merchant has struck again. Hold on, y'all. I'm trying my phone trying to die. Merchant has struck again after the 8 justice who participated in the decision anonymously granted a right certiorari as to both the emergency motion and appeal of the attempt order. They ruled that, okay? When he said they weren't going to rule it, they did it. When the appeal, the contempt order is doctored in the Court of Appeals, the Court of Appeals is directed to transfer that appeal and record and records to this court. Residing Justice Neil Peterson did not participate. Now, this is something else. I can remember that name. That's something else. Okay. So, anyway, other words, your boy still did get a bond. We are thrilled that they put that right here for about Mr. Thrill. I'm so glad for Mr. Brian Steele myself, because I don't think that you should threaten somebody because they won't tell you something that they ain't got no rights themselves. Y'all people start thinking y'all ain't got no rights, because y'all do. We are thrilled that Brian will be home with his family for Father's Day this weekend. Merchant told the Atlanta Journal and Constitution, we appreciate how quickly and thoughtfully our appellate courts handled this unfortunate situation. Merchant who chairs the state's criminal defense attorney association rushed to the courtroom to defend Steele on Monday after Glanville held Steele in contempt for refusing to reveal how he learned about an ex parte meeting that the judge held in his chamber with prosecutors and with Lil Woody, okay? And Woody counselor. Ain't that something, y'all? Still is at home with his family for Father's Day. That is good because he's a great father. Still raised concern that none of the defense attorneys involved in the sweeping RICO case had been made aware of the meeting. He claimed that the judge and the prosecutors engaged in witness tampering during the meeting by telling witness Lil Woody, whose real name is Kenneth Copeland, that he could remain in custody until prosecution of the 28 core defense defendants in the case had ended. That's what Miss Love told him. Only 6 of their cases have gone to trial, but the proceedings are accepted to continue into 2025. So, yeah, we got a long way to go on this RICO. It's not going to end in 2024. So, y'all might well get you some watermelon. Okay, indicted alongside the others in the case, Young Thug, whose real name is Jeffrey Williams, is facing charges related to racketeering, conspiracy, participation in criminal street gang activity, along with drug and gun charges. Williams' attorney still said that YSL stands for his record label, which it does, Stone of Life. But prosecutor claimed it could also represent Young Slime Life as alleged violent street gang in Atlanta. The investigators say Williams helped found. Williams has pleaded not guilty to all charges. Okay, the Georgia Code of Judicial Conduct generally prohibits ex parte communication on substantive matters, which they are exception where those presentation are allowed. They require a judge to prompt notify all parties and give them an opportunity to respond. Ex parte communications are ones that can be without advance notice and can exclude certain parties. Glanville decision to hold Steele in contempt and sentence him to 20 days behind bars, the maximum punishment in Georgia for criminal contempt, and Atlanta attorneys. Merchant said Monday that dozens of other lawyers also showed up in a solidarity agreeing that Glanville should have included defense counsels in this meeting, at least provide a transcript of what was said in the chambers. What's up, Imperial? We're not okay with this. She said, a still arrest. We're not going to let this happen to our brother who was simply doing his job. I like them. I mean, y'all be my attorney. Glanville has been determined to find out the source of information leak. On Tuesday, he rescheduled a June 25th hearing for the Fulton County prosecutors who attend the meeting. Glanville said they are to appeal and show causes for why they should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsels. Defense attorney Doug Weinstein, who is representing Diamante Kendrick in the YSL trial, asked the judge Wednesday to recuse himself and for the trial to be halted so another judge could decide if Glanville should step aside. It ain't like we want to get rid of him, but I think he need to step down. I really do, y'all. Because they taking advantage of that man. Aren't you interested in removing the cloud that is hanging over the case right now? Weinstein asked. Glanville denied it, the request, and warned Weinstein to be very careful about what he was asking for. You can't threaten that man for recusing you. That's the problem. That's the problem. I just want to bring all this good old delicious information to y'all. Y'all know, look now, tomorrow, y'all, I got business to take care of. I got it for this job. So I'm going everything I find, I'm gonna bring it up to y'all, and I'm gonna show y'all. And I appreciate y'all showing up and participating. But I had to bring this up, but I did not know that this was that Ashley, who was in court, was Miss Fani Willis rifle. Hey, it's nothing else I can say. I just want to bring this information to you. Hey, he got a bond. You say he couldn't get one. See, I'm gonna tell you that Rico case. That Rico. Okay, true. Oh, truth. I'm about to go check on what Judge Joe Brown said about Fani Willis. I'm gonna see what he says. And tell you my point of view on that. Okay, I love y'all. Y'all have a good night. Okay, love y'all. I'm out of here.